Every 3 years, you're eligible to have your child support order reviewed without having any valid, unusual reason or any change.
So we have another wonderful program today. We're talking to Diana Del Rio. She is the program director of the Family Support Program. And Diana, thank you so much for spending time with us today.
Oh, you're so welcome. I'm happy to do it.
What are some of the things that help to allow people to modify their child support agreement?
Every 3 years, you're eligible to have your child support order reviewed without having any valid, unusual reason or any change. If you're within the 3-year period and something has changed, then we call that a change of circumstance modification.
Okay.
So for example, if you, let's say one of the parties has a new child that wasn't considered at the time the order was taken, and they get credit for the children that they're obligated to support beyond the one child or the children in question,
Gotcha.
On our order. So they would be eligible for a credit. So maybe they want to modify because they have a new child and they want that considered. Or somebody loses their job, or they've got a higher paying job, or the parenting plan has changed, the number of overnights per year that a parent might have, they get credit for each night. So there's a variety of different reasons, and if your order is under 3 years old, you can request a change of circumstance modification, and we would evaluate the case.
What is your point of reference? What are you always looking for as you're setting those up?
We go through a discovery phase, which is another term that all legal actions, whether they're criminal or civil, have a discovery phase where you can learn the facts of the case and the situation. So we go through this discovery phase, and what that means to us is that we provide the parties with documents to fill out, paperwork, and we want them to tell us about their situation. What do they earn? What is their ability to pay? What is their lifestyle? Again, do they have other children? Do they pay costs for daycare that should be considered in the calculation? Because I think anyone who has a young child knows those costs are really exorbitant. I think infants could be like $1,000 a month for daycare. So we get all of those kinds of facts from the parties, but we also ask for documentation. So it wouldn't be like they're just going to fill it out and we're going to go with it. So that's the protection for both sides. And in addition to that, we will send out informational requests to the employer so we can compare what they're telling us with what the employer says they earn, and we also would want their wage statement, their wage stub, and we also have access to a variety of databases, so we can check wages and other kinds of information. So we put all that together, and we include those details in our calculation, and we come up with a proposed child support order, which is what we serve. It's proposed until we go through the whole legal process for it to become final.